Hello everyone, hope you're doing well. You're joining us today for session 4, nuts and bolts of your tribal juvenile law. And this is the 4th session of the Introductory Tribal Juvenile Policy and Code Development course. It's hosted here by the OJJDP Tribal Youth Training and Technical Assistance Center. And we are, of course, happy to have again our presenter, Pat Sika-Kwaptua, and I do call her Pat, but we are so thankful that she is the Honorable Pat Sika-Kwaptua. She currently sits on the Hopi Appellate Court, and she's joining from the University of Alaska Fairbanks, working in the Department of Alaska Native Studies and Rural Development. And for those of you that have been able to join us for sessions 1 through 3, we do have a longer bio for Pat, and we were able to present that on session 1. But if you want to read her bio or also have some contact information, it is available to you in the download pod. So thank you, Pat, again for joining us for session 4. And I am Anna Rangel Clough, and I work here at the center. I'm currently serving as the assistant director, and we are so glad that you guys are joining us today. Feel free to enter in the chat box your name, where you're joining from, what community you're from, your role. I know that several of you have joined previously, and so we're happy that you're back, but if you are just now joining this series, feel free to say hello, where you're joining from, what your role is within your community or your tribal justice system, so that we can get a better feel for who's with us today. And for those of you that have made it to this far, all the way to session 4, we did want to let you know that we will be archiving sessions 1 through 3. So if you want to go back and review material, we will have those links for you available hopefully before we close out the session, but if not, we will be emailing you all information on how to access this series and all the archived webinars, and then we'll send you links to other resources and information that are available through the TTA Center. So thank you again. Thank you for typing in our chat box. Chloe and Chris again, hello. Thank you all. Feel free to introduce yourself. I know we have several TTA Center staff that are joining as well, and so with that, we're going to move on through our presentation. So just an opening welcome. We've done a welcoming every single time, but we're just so thankful that you all are here for today. If you just want to say how you're doing, any activities that you've got going on this summer. I know I was able to go to our tribal festival here a couple weekends ago, and that was a lot of fun, and I always like summer because there's, a few days off here and there. So really glad to be back and joining you all today. So let us know if you have fun summer plans, or if your tribe has a festival or an activity that you guys are focused on right now. Really love to hear about all the different things going on and all the communities that we have joining. So appreciate you all being here today. I'll wait just a minute to see if any of you all are going to share with us. Feel free to keep using that chat box. Chris is sewing dresses for ceremony, yes. It's always something fun to do with your family and sisters and daughters. Nick, I'm going to let you talking about the nuts and bolts of tribal juvenile law. And I gave an intro already and told you we're going to do questions and closing at the end. And again, thank you for all of you, our friends who've been with us through sessions 1 through 3. I won't dawdle for your sake, but for those who are joining for the first time, if you have any questions whatsoever, feel free to type those in the Q&A box. And then if you just want to have a comment about anything, put that in the chat box. We're happy to serve you here at the TTA Center. Our email, address, phone number, and website are there on the screen for you, and you can also get that when you download the presentation. Reach out to us anytime for any assistance whatsoever related to training and technical assistance. We're also able to provide services for any federally recognized tribe or any community that's trying to implement something that's going to support tribal populations. So reach out to us at any time at these contact numbers and at our email address. There's a quick snapshot of our website. You can visit it anytime and request training and technical assistance. And with that, we're going to have a few polling questions, and Nick is going to pull those up. And these are, again, just to get a feel for where you're at in your particular community on some issues that we thought of, really more what Pat had on her mind as we're working through the content for this particular session. So how many of you, and these questions will be in pairs, and we're going to have those up. And Pat, feel free to interject at any point in time for some feedback, but which of the following positions are funded within your current tribal juvenile justice system? And there's several choices there, so make sure and scroll down if you can't see them all. But if those positions are filled within your current tribal juvenile justice system and they're funded, just to get an idea of what kind of positions are currently in your community and being funded. And then the second question is, which of the following services are missing from your tribe's array of services? And on that particular question, you can make sure and scroll down because there are a couple of options at the bottom. And Pat, I know that these are probably different roles and things that you've seen in your work throughout Indian country, correct?
They are, and we have tribes all over the country in really different circumstances. For example, up here in Alaska, we don't always have tribes that have law enforcement or tribal social services, so they may be using their ICWA worker for all kinds of things. And in other parts of the country, we have fully fleshed out tribal court systems. They function, with dockets just like the state superior courts do, and they have all or many of the roles. And we'll talk about that some in the slide set.
Right. I definitely think that many of you who are joining will understand that, you may have someone on your team that wears many hats, and that capacity differs based on the size of your community and what's able to be funded. And so when we ask you guys what your roles and responsibilities are, for some of you, you may be carrying a very heavy load. And so we're really happy just to be here and support you all as you try to make a difference in each of your communities. And we're really appreciative when you do share, because I think it's important for us to have that understanding that many people in your community are trying to do good things, and many of you carry a very heavy load as you try to do that. And so it's helpful to understand and to have, support from, different places, and we're definitely here to support you. So thank you for sharing. And Pat, I can see that, we'll go back. We can go back and assess those in just a bit. We have 2 more questions we wanted to ask. Would you like to describe or say more about a particular service that your tribe uses and that works well? And you can type that answer. And then, does your tribal juvenile court use any of the following? And there you can see elders panel, tribal council, peacemaking, circle process, restitution, or community service. And I know community service was we used that quite often when I served as a prosecutor. I know that the judges regularly utilized that. And then actually, within being able to serve at the tribal complex in different ways, there was a variety of options that we had available for people to do community service in lieu of heavy fines or other things. That seems to be a hit, 83%, Pat, do have community service. I see restitution is the close second, and then circle, peacemaking. We've got 1 response there for each of those. So any of these options, and we don't have an other, but if you have an other, you could put that in our chat box. Do you use any of these following? Panels, councils, peacemaking, circle processes, restitution, community service? If you have an other, feel free to chat that to us. We can look at that. Up at the top on number 3, I see CASA. That's a service that your tribe uses and it works well. So thank you all for sharing those. I see custody investigations, and then NA not applicable. All right, we can go ahead and close those out. And then Pat, I will have you go ahead and talk about today's learning objectives.
Hey, thank you, Anna. And thank you for having me back, and thank you for hanging in there with us through the 4th session today. Today we're going to be coming back and really looking in detail again at the 2016 Model Juvenile Code. And some of the things we're going to be looking at, we have been talking about subject matter jurisdiction in the sense of looking at what is juvenile delinquency, what is family in need of services or children in need of services. Those are the categories of, I wouldn't say offenses, but conduct that bring youth into a juvenile court. So today we're also going to look at related personnel in the juvenile justice system and their responsibilities. And then we're going to go over some of the basic provisions of the juvenile delinquency statute under the Model Code for 2016. All right, so we should all be looking at slide 10 here. And I wanted to talk about some of the key figures in juvenile court proceedings. And I realized that I needed to talk about what we tend to call them and what they're called under the Model Juvenile Code. So we understand our juvenile systems to have different actors. The police, there may be a probation officer, and indeed from your polling questions, it looks like quite a number of you have juvenile probation officers. We may also have prosecutors and defense attorneys. We have tribal judges. We may have child and family services personnel. We may have guardians ad litem, and we might have court-appointed special advocates. So let me just go back up to the top and remind you how the terminology changes when we look at the Model Juvenile Code today. So in the code, in the Model Code today, we're going to see that police are referred to as law enforcement officers, or LEOs. And juvenile probation officers do not appear in the Model Code. Instead, we have something called the Juvenile Case Coordinator. And that may be reflective of the desire to make the system not look so criminal, so that it looks more civil/therapeutic and less like an adult criminal justice system. The prosecutor is titled the Juvenile Presenting Officer, and indeed in many tribal codes they already do call this person a presenting officer. Defense counsel under the Model Code falls into 2 different categories. They either refer to this position as private counsel, meaning that a youth and his family went and hired their own lawyer, or a juvenile advocate, meaning they couldn't afford their own lawyer, and so the court appointed a lawyer for them, and that person is known as the juvenile advocate. And then, of course, the tribal judge is specific to the juvenile court is the juvenile court judge. And as you can see, I put the acronyms after them because sometimes in the diagrams I can't fit the whole name. So I'll try to remind you what each one means. Okay, so when we come down to child and family services personnel, there's a huge variance in what tribes designate this role to be inside their own systems. So Some of them designate these people tribal social services workers. Some of them designate them tribal child protective services workers. And in Alaska, we often see ICWA workers filling the role of these tribal positions. However, their job is also to go to state court in ICWA cases and represent the interests of the tribe, not so much as a lawyer, but as a representative. Okay, and then for guardians ad litem, they're also known as GALs, and court-appointed special advocates are also known as CASAs. And we'll go on and see what these different roles do in the system. Oh, before I move forward, though, I wanted to point out that in some tribes, they don't have all the lawyers. And so a lot of these lawyerly roles, like the juvenile presenting officer or the, let's see, there was another one here. The juvenile presenting officer is the primary role that sometimes defaults to someone who is a tribal social services worker or an ICWA worker. And, you know, those of us who are law trained might reel in horror to think that we're going to dump a legal role onto someone who's on the social services side of things. But it happens all the time. I see it when I go out on site visits working with tribal courts. So the key thing to remember here, then, is if your role, if the role you're in is not a legal role in your training, but it becomes your role in reality, that you go to the code and you understand how to operate. It's like putting on the hat of a lawyer. How can I operate in the role of a presenting officer in following the code? And so for those moments when you're coming to a hearing as a juvenile presenting officer, you are acting in your legal role. You're changing your hat for a brief amount of time. Okay, so there's a certain number of roles here or positions that are especially important in a juvenile court docket. And so I pulled out 3 of those here. And the first one is the juvenile probation officer, or in the code it's called the juvenile case coordinator. So this person under the model code is a liaison. They characterize this person as an unbiased liaison between the child's parent, guardian, or custodian. And I'm going to call because a child may have any one of these, I'm going to call this cluster of parent, guardian, or custodian PGC. So every time we hit PGC, you know it could be the child's parent, guardian, or custodian. Okay, so the juvenile case coordinator is a liaison then between the child, the PGCs, tribal agencies, service providers, school officials, victims, the presenting officer, and the juvenile court. And it's interesting that they were very careful to put unbiased on the front. So the juvenile case coordinator is not the child's lawyer, for example. They're also not a CASA. They're very much unbiased in this process. So in addition to being a liaison, this case coordinator under the model is also responsible for coordinating services for the child and his or her family, or providing recommendations to the juvenile presenting officer about whether or not to file papers in tribal court. They also provide recommendations on how to dispose of a case, you know, what we might think of as sentencing in the criminal system, you know, what kind of dispositions for juveniles should be handed down by the judge. So the judge is going to listen with special care to the recommendations of the juvenile case coordinator. And then the juvenile case coordinator is also responsible for monitoring and facilitating compliance. Is the child, is the PGC complying with their diversion agreements, any conditions of release, or any disposition or other orders from the court? So you can see there's a probation officer aspect to the duties of the juvenile case coordinator here. They also are responsible for making sure that mental health and other screenings take place if they're warranted. And they may have other special functions that are delegated under the law. The model code is pretty thick, and there's many segments to it. We're only looking at the juvenile delinquency segments today. And the juvenile case coordinator most likely has responsibilities in other parts of that code as well. Okay, let's look at another position here. Let's look at the defense counsel, or under the model, the private counsel or juvenile advocate position. So ideally, this person is a lawyer, an attorney, a licensed attorney. If we're talking about the juvenile advocate, this is an attorney who is not the private counsel. It's the one appointed by the juvenile court. And their job is to represent, as a lawyer, the child in proceedings under this model code. So all juvenile delinquency proceedings. Okay, let's look at one more position here. The prosecutor, also known as the juvenile presenting officer under the model code. Again, this is the lawyer, but this is the lawyer for the tribe. He or she works for the tribe, and they handle all sort of prosecutorial type matters before the juvenile court. So in our case, they're filing delinquency petitions against youth who are alleged to have committed a delinquent act, which usually means they're alleged to have committed a crime under the tribe's law and order code. Okay, so there was another aspect of the model code that I thought was pretty valuable, and I do not see this in tribal codes. So there's a provision in the model code called Directory of Services, and basically the model code is delegating to the juvenile case coordinator the responsibility of compiling and maintaining a directory of services and resources for youth and their families. And so I had you check a list in the polling question of whether you had all of these or you might want some of these. It's a pretty comprehensive list of services and resources. So things like crisis intervention, counseling, mediation, victim offender mediation, programs for prevention and diversion, assistance in education for victims and perpetrators of domestic violence, parent training, homemaker programs, housekeeping programs, respite care. I remember when I first was compiling this resource that this webinar is based on, I was wondering, what do they mean by respite care? Because I almost never see this in tribal communities. So I dug around a bit, and I found a program, I believe it was in New York City, where they have basically a residential resource center for youth. So if you have kids that are not getting along with their parents, or maybe they're running away from home, or maybe their parents are not getting along with them, they can actually go to these centers and stay there for, a couple of nights or maybe a couple of weeks and get screened and get services, and then they go back home again. And I've never seen anything like that in the tribal communities that I work with. So short-term respite care, number 10, would be my choice of what I would love to see in our communities so that, some of that steam can get blown off and youth and their families can get earlier resources and interventions than they would before going to court. Okay, so there's a whole bunch of things here. What I like about this provision is that the code is mandating the obligation to list or compile these resources and update these resources with the juvenile case coordinator. So this becomes a significant part of their job description. Another thing I would say here is that I often say that if you have a juvenile healing to wellness court, that your court is only as good as your treatment services and your other activities and programming. And, you can put all the court infrastructure in place, But if you don't actually have the services and resources underneath that will help people, then the system really won't work. And I also feel that way about the juvenile court docket. If you don't have all the services and programming in place, you're just funneling people through a bureaucratic system, and there's no therapeutic benefit. And it starts to look more and more like an adult criminal system. Okay, just a little more on the directory of services. So the code also mandates that the juvenile case coordinator consult periodically with agencies and entities that provide services to children, and to make sure basically that they are listing all the resources and services, and also they all know about each other's resources and services. And then I also wanted to just show you this list of prevention and diversion programs that we tend to see when we're looking at tribal programs. So you might have programs that you could think of as prevention. And then I put a slash in my mind here and say there's also many programs that are intervention. And some at the bottom of our list here are more like intervention, like drug courts. You actually may be directing people to residential treatment or intensive outpatient treatment. That starts looking a lot like intervention to me. Okay, so diversion programs, that means you're trying to divert something away from the tribal court and into another program, and if they're successful, they may not have to go back to tribal court. There's school programs. There may be wilderness programs, or what we think of in many places, culture camps. Restorative justice programs, everything from mediation to peacemaking to circle process. This is a broad category here. And then, of course, there's children's and family services. There may be special federal programs at any given time. And, of course, we're seeing a lot of drug courts known as tribal to healing to wellness courts and teen courts as well. And there may also be child abuse and neglect prevention programs. So this is just a generic list of the kinds of programming that we might often see with a tribal court. I don't think any tribe has all of these, but many tribes have many of these. Okay, so I just want to pause here for a minute. Are there any questions and comments so far?
You guys can type your questions in the Q&A box and then offer comments in the chat. But I did want to also support Pat in that statement that if you are a Juvenile Healing to Wellness tribal grantee and you're joining us, I think that list on slide 14 is a really great place to start. Even if you're not fully implementing this model code, this is a great place to start with your team if you want to start looking at asset mapping on what's available in your community. The Technical Assistance Center can support you if you don't know how to do an asset map, but if you do, I think this is a really nice list to look at. What's available in your community now, and what's something that's accessible through a partnership or a collaboration. And this is definitely a great slide to keep on hand. And I also would secondarily comment that exactly what Pat said, your court is only going to be as successful as, what offerings are you making to actually support the youth that are coming into the system. And so however you're developing your juvenile justice system, just to look at what you're integrating and what's really going to be effective to support them in reducing recidivism and then also providing for accessible treatment for them. So I really appreciate you sharing those slides, Pat.
Thank you. Okay, so I'm not seeing any questions or comments so far, but if you see them, Anna, just jump right in.
I will do so.
Okay, so let's go back to our diagram on slide 17. So this diagram, I think, if I step back from it, I really do see a tension in the model code and in all tribal codes, actually, or many tribal codes. There's a tension between viewing the juvenile justice system as designed to be therapeutic, and at the same time designed to be about accountability and to a certain extent punishment. And we're going to see sort of two sides of that again here today. At the start of this session, we've been talking about the roles of different actors in the juvenile justice system and how there are sort of therapeutic aspects to what they're supposed to be doing, helping youth, helping families, making sure they get services. And when we look at the court process now, we're going to see that there are doors to therapeutic interventions. At this point, we're really looking at a lot more intervention than prevention. And the model code creates 4 doors to those kinds of services, which are the big blue bubbles that you're seeing on slide 17. However, there is still a trial court process going on at the same time. And this is looking for things like guilt, in a way. Did the youth commit the crime, in a sense? And it's still, you've still got a judge who can find them guilty, in a sense, although we call that something different in the juvenile context. And it's still possible for them to end up in secure detention. It's still possible for them to be accountable for a crime, in a sense, and have to pay restitution, for example. All of that can still happen in the system under the model code. However, the model code definitely leans more to juvenile rights and more to therapeutic possibilities, and it puts more burden on the judge and the lawyers in the system to have to really demonstrate why the kid should not get diversion to some therapeutic option. And it makes it really hard to send someone to secure detention. But that's still a possibility under the model code. So again, that tension here between you know, a rehabilitative approach for youth and a punitive approach for youth. There's still that tension in this system no matter what we do to it. But the model code definitely tips more rehabilitative. Okay, so the 4 doors then. Let me just talk you through the process across the top, just so we remember. So let's say that a youth is alleged to have stolen something, stolen a car. We'll make it a car. So that's a crime. Stealing a car is usually a crime under tribal law, under the Law and Order Code. So there's an allegation then that this youth has committed a delinquent act. And once that becomes, once the juvenile case coordinator is notified of this, they investigate and they figure out whether there's enough factual information there for them to be bringing that matter and that youth into the court system. So if they decide there's enough information and that it's likely that this happened, they may meet with the child and parents in conferences and see if they can reach a diversion agreement that maybe provides services and other things to the child and the family so that they never have to go to court. So that's the first door, that informal adjustment and diversion agreement. And if the parents and child comply with that agreement, they may never have to go to court. But let's assume that doesn't work. And they end up, the juvenile case coordinator ends up recommending to the juvenile presenting officer, who is the prosecutor, that they should file a delinquency petition in tribal court. So at that point, now the juvenile presenting officer is going to have to prove or get the kid to admit that they committed a crime. So once that petition is filed, then there are three big hearings that happen in sequence. The first is, and I shouldn't say they're all big, the first one's a little hearing. It's the initial hearing. And then there is an adjudication, which is also a hearing, and we think of that as a trial. And then there's a disposition hearing, and we often think of that as a sentencing hearing. Okay, so I'm going to go into more detail about that in a moment. But for now, I want you to see the doors. So the second door to diversion here, door to therapeutic or rehabilitative possibilities, is something called deferred adjudication. So in between that first court hearing and the adjudication or trial, it's possible for someone to make a motion to say, hey, let's not hold the adjudication. Let's go back and see if we can modify that diversion agreement and try it again. And so they may, if the judge approves of it, they may do that. And if it's successful, that may be the end of the whole thing, and then the judge can dismiss the delinquency petition, and it's all done. But if that doesn't work out, or the judge doesn't grant the motion for deferred adjudication, then the whole thing goes to trial. And then the judge will set a sentencing hearing, assuming they find that the youth committed the delinquent act. But in between adjudication and the disposition hearing, someone can make a motion for a deferred disposition, and then they go back at it again and see if they can go back to that refined diversion agreement and get the parents and youth to comply and to successfully complete the conditions. And if that doesn't work, then we're back to the disposition hearing and, in a sense, sentencing. Okay, so there's four possibilities then, four doors to rehabilitation or therapeutic intervention, which can also include the cultural issues and cultural programming. Okay, let me just pause there for a minute. Any questions about the doors here or comments?
I wanted just to see from our audience if they see often, if you served in the tribal court, those conditions that we order at the time they're adjudicated are often kind of that reverse back into the court when they don't follow them. And so you kind of see that cyclical non-compliance, and it's almost like if we don't take a step to really provide effective intervention, it's like they're repeating back into the process over and over because they can't meet the conditions for whatever reason, if there are fines or other things attached, or if we just haven't thought of, you know, options that are really going to work for the family as far as what they've been assigned to. And I definitely agree that for most of us that are joining, that there is that aspect of, you know, truly that there needs to be accountability and understanding if a wrong has been committed. But as the justice system is able to provide options to intervene, what are we doing to ensure that we're not looping them right back into the system?
Yeah, and I think that, the thing that pops into my mind about the kids who are just going round and round is case management. You know, how effective is our case management of that youth and his or her family? Where are the cracks? Why are they falling through? Is it because we don't have a good array of services, or maybe we haven't done the evaluations to make sure they can get them and access them? Or is this a kid that just really does not belong on the rehabilitation side of things? Yeah, that's a very wormy issue.
Right, and I do recall we had a session in 2016 at our national conference, and you know, I know there were a couple of judges that have been working in juvenile healing to wellness for a while now, and you know, they both said that, you know, while we want to focus on providing every service possible, you know, if there's a youth who truly is non-compliant and not ready and willing to be a part of that healing process, that maybe they don't belong on that particular docket. And so when you're looking at how you want to develop your code, ensuring that there's options there for moving them from one program to another, I think that's a definite consideration.
Oh, and I should say that these blue bubbles are where you would move them to Juvenile Healing to Wellness Court. So under the model code, it looks like you could do it in 4 different places, all the way to the disposition order, actually. Now, I do understand in drug court circles, there are preferred mechanisms for moving youth at different stages here. But just to let you know, the model code has 4 doors for it, and you could modify that when you wrote your code up. And I do see there's a question here. Are there certain offenses that disqualify a juvenile from participating in the Healing to Wellness Court program? I know that there are federal funding limitations, and I know that your tribe could also create their own limitations, but I thought maybe you might want to say something about the federal funding limitations.
Right. So this came up, I think, on our previous webinar, but in both the 2016 and the 2017 CTAS solicitation, there is a note about violent offenders, and I'll actually post that again. I'll put that in the chat box shortly. But make sure, and if you are utilizing a funding stream to support your whatever process in the court you're developing, to look at any requirements related to offenses. But for sure, in the 2016 and 2017 CTAS solicitation, there are indicators for violent offenders related to healing to wellness, and I'll post those here shortly.
And then my answer on the other end of it, looking at it from sort of a tribal policy and lawmaking perspective. So a couple of years back, I reviewed some of the tribal drug court evaluations, and the number one offense that was popping up that shouldn't be included is bootlegging and drug dealing. So there was a lot of concern in tribal communities that people who are bootleggers or drug dealers should not be allowed into Healing to Wellness courts because that's their prime clientele, right? And that it might undermine the therapeutic culture. That said, I do recognize that a lot of the youth that are in those programs may somehow be involved in bootlegging and drug dealing. So that's a tricky one, but it would be an example of a type of crime or crimes that might not qualify someone under tribal law and policy for a Healing to Wellness court. Okay, so I've shown you the doors, but what happens when you send somebody through those doors? Under the model code, they list a whole bunch of diversion options. These are things that can be conditions of a diversion agreement, and those agreements can have a combination of these things in them. So there's like a list here. I'm just going to review it. So it's possible that the juvenile case coordinator or the judge in a court order would refer the child and his PGC to social, community, or tribal services or resources. They might also be referred to an elders panel, a community accountability board, a tribal council, or other forum suitable for addressing the needs of both the child and the community. They might be required or agreeing to participate in tribal peacemaking or other extrajudicial alternatives for resolving conflicts or disputes. Participating in cultural, educational, or other programs or activities. Particularly, they're looking at things that deal with rehabilitation, community involvement, competency development. Yeah, I'll leave it at that. Another is participation in educational or counseling programs to deter delinquent acts. Participation in educational or counseling programs designed to contribute to their ability to care for and supervise the child. This is for the child's PGC. Number 7, the requirement that the child and or the PGC undergo medical, psychological, or psychiatric examination or treatment. There might be a requirement that the child pay restitution, that the child perform community service, that the child maintain satisfactory school attendance or pursue a course of study. There might be a requirement that the child participate in a structured after-school evening or other court-approved program. That could be drug court or healing to wellness court right there. And then any other reasonable conditions that do these things, that hold the child accountable, that provide for the safety and protection of the community, or that promote the development of competencies for the child so that they can become a responsible and productive member of the community. So those diversion agreements are really a place where all kinds of things, which we think of as conditions on a child and their parents, guardians, or custodians, there could be all kinds of things put in that diversion agreement. It needs to be reasonable, and it should be targeted individually to their specific circumstances. But you can see there's just a whole lot here, and that you could integrate into this a requirement that they participate in a healing to wellness court or a drug court. Okay, I'll just check in one more time, Anna. Any questions or comments here?
I don't see any questions right now.
Okay. Some of the feedback we got in between sessions is that we needed to give you more chiming in time, so I'll try to remember to do that. Okay, so there's still a little bit more model code here on these diversion agreements. Oh, I see why I included this one. So here we see one of the model code's preferences for, or I should say, not preferencing secure detention. So the conditions of a diversion agreement here shall not include detention in a secure juvenile detention facility. So that can never be one of the requirements in a diversion agreement. It also shall not include the requirement that the child's parent, guardian, or custodian undergo medical, psychological, or psychiatric treatment unless it's recommended by a medical, psychological, or psychiatric professional, and it's necessary to address the conditions which contributed to the alleged delinquent act, or allow the child to remain with or be returned to the custody of the PGC. All right, so I guess the two things I just wanted you to see there is that the model code doesn't let you put a kid or a youth in secure detention, and there's very specific requirements for requiring psychological and medical, psychological, and psychiatric treatment for parents. Okay, so let's come back to our diagram again. And what I'd like to focus on at this point is the process of the initial hearing. So I'm going to go back through here, and we're going to talk about, all we're going to have time for in this session really is to look at two hearings, the initial hearing and the adjudication. And the adjudication will take up the bulk of the time here because it is a trial, and we have to think about legal issues if we're looking at, finding somebody guilty of something. So the first thing I need to say about this diagram is that if you look at the initial hearing box, look above it, it says acceptance of guilty pleas. So in most court systems, when you have this initial or preliminary hearing, you're asking somebody to plead guilty. Do you plead guilty or not guilty, or are you doing a no-low plea, which I'm not even going to explain right now. But that plea process does not exist in the model code at the initial hearing stage. As a matter of fact, they don't let you do it. So if you can just in your mind circle acceptance of guilty pleas on the diagram and move it over to the top of adjudication, that is what the model code is doing. It's saying you have to do that at the trial at the front. You cannot do that at the initial hearing. And they're talking to the judge. They're saying, Judge, you can't take a guilty plea, or you can't take a plea at the initial hearing. Why, you might ask? Because there has been a tendency in tribal juvenile court for there never to be a trial at all, and for the judge to just ask the youth to plead and then get them to admit they did it, and then use that admission in lieu of having any trial at all, and then going straight to the sentencing or disposition hearing. And criminal defense lawyers would cringe when they see that, they cringe, because they feel as though all the rights protections for criminal defendants are being thrown out the window. And indeed, we did see some of that in the state court systems when they moved during the era of rehabilitation in the late 1800s, early 1900s, where they said, oh, our courts are about therapeutic, rehabilitative approaches to youth, and so we don't need to follow all that process in the adult criminal court. It's unnecessary, and then the judges would end up sentencing these youth to these reform schools for many, many years, which effectively were secure detention facilities in some sense. Some of that is happening in our tribal court systems. So the model code is really an attempt by the drafters who are criminal defense lawyers to put that more rigorous rights protective process back into the system. And so they want to make it really hard for a judge to take a guilty plea and an admission of guilt from a young person and then sentence them. And so you're going to see that as we move through this code. All right, let me just say a little bit about the purpose of this initial hearing, and then we'll go into more detail in the next few slides. So the purpose of the initial hearing under the model code is to do four things. To advise the young person of their rights, to determine whether there's probable cause to believe that the child committed the delinquent act that they're alleged to have committed. The third is to consider dismissing this whole thing and diverting it, so send it back to that informal conference and agreement process. And then the fourth is, are there other reasons to dismiss this? Would this whole matter with this young person be better handled by their PGC or in peacemaking or in restitution or in some other process? So I sort of think of the model code's initial hearing as all about rights and trying to knock this case out of the court process. Oh, and then I should point out here, it is possible that at the initial hearing, someone may make a motion anyway to defer adjudication, right? That's one of those doorways we just looked at, and have this whole thing diverted anyway. So if someone makes that motion, and there's actually a provision in the model code that says the juvenile court has to grant that motion unless it finds that the proposed conditions are unreasonable, considering the nature and seriousness of the allegations, the needs of the child, and the safety of the community. And so the judge can deny a motion for deferred adjudication, but they have to really look at those criteria in order to do so. And just so it's on the recording, that is Section 2.09.110 of the model code, the criteria. All right, so let's take a look at some of the details surrounding the initial hearing. Okay, so there's a provision in the model code called conduct. How do you conduct the initial hearing? And the first thing that they require the juvenile court to do, and by the way, when they say juvenile court, they mean the judge. So the first thing the court or the judge has to do is the judge has to advise the child or advise the youth. And they have to do it in a language the child will easily understand. And here's the list of things they have to tell that young person. They have to explain the nature and purpose of that particular hearing that they're in and the proceedings going forward. They have to explain the contents of the delinquency petition. You know, they'll have to say, hey, I have a petition here from the presenting officer that says you stole a car. And, you know, you're being charged with, or in a sense, you're being found to be a delinquent because, you know, we have this information saying that you stole a car. The third is that the judge has to convey or explain to the child the possible consequences if they are found to have committed a delinquent act. Well, what's going to happen to me? You know, if you find I'm a delinquent, well, the judge needs to explain the possibilities, especially if secure detention is a possibility. Also, the judge explains that he or she has a right to counsel, that he or she doesn't have to talk to the judge, they have a right to be silent, that they have a right to a trial, which we're calling an adjudication here, and that in that trial, they have a right to ask questions of the witnesses against them. They have a right to testify if they want to. They have a right to call witnesses in their favor. They have a right to introduce evidence in their favor. And they have a right to an appeal of a final order from the juvenile court. And then at the very bottom of that, the law says, the juvenile court shall not accept an admission at the initial hearing. So no taking of pleas, no acceptance of admissions of committing, you know, stealing cars. That cannot be done under the model code at the initial hearing. Okay, I'm just going to pause here a minute. Any comments or questions? Anna, do you have any reflections?
I just wondered if our audience had any thoughts on all of the roles and responsibilities that we've discussed so far. How many of you that are on are currently developing a healing to wellness court, or you know, are looking at some other diversionary process, and just thoughts on the 2016 model code as it stands right now, if you've had time to reflect. I know that was a question that we left with last time. If you were on session 3, was, you know, thoughts about implementing 2016 model code in whole, and then any concerns that you had. And so I didn't know if anybody had time to think about that or had comments about that.
Yeah, and, you know, as you can see, it's starting to get very Law and Order-ish, like the TV show here, as we move through the model code. And so my sort of gut reflection after the last session is that, wow, this is a lot of due process. This is a lot of process. It's very much like criminal court process in terms of protecting rights. And I started to sort of ponder, you know, what happens to the tribal court system if you import all this Western adversarial criminal process into the tribal court system, especially when most tribes have not done this historically. Some do, and some are very good at it. Others are very, you know, I myself come from a really traditional tribe, Hopi, in Arizona, and I work with tribes up in Alaska that also have very traditional systems. And so to import this process into their traditional tribal court system or their circle process would sort of explode it into something else. I always like to say you can't be halfway adversarial, or it's kind of like you can't be halfway pregnant. at some point when you pull in enough Western process into your system, you become a Western adversarial style system. It's hard to just do it part way. So it raised all kinds of sort of controversial questions in my mind about how far you can follow this model code before you completely change your system.
Right.
Or maybe you add a docket that is a separate docket and you triage cases into one or the other. I don't know, but those are the kind of bigger philosophical things that popped up.
I agree. I also think, when we start getting into that philosophy do we also include approach? Because I think the vast majority of us would say that, due process in and of itself, and then that extension of those rights that you're owed as an individual within the community. I don't think that's in disagreement with a system. It doesn't have to be adversarial. Maybe it's like, okay, we can take all of these, we can ensure that youth have rights, we can ensure that our judicial staff and programs are being fair. Is it an approach issue? And so we guarantee these rights, but our approach is not going to be an adversarial approach. And how do you balance that? And so I definitely see those concerns that come up when you're looking at if you were to just adopt this in whole, like how does that fit within your system and still keep it a truly diversionary system?
Okay, somebody did put in a question from Daniel who says, it seems like the initial hearing, you know what, you might have to read this one, Anna, because I can only see part of it.
Yeah, I can do that. It says, it seems like the initial hearing is only an informative session for the youth and their parents. Question, should a judge be expected to spend their time informing each youth to make them sure that they understand all of this at their age and degree of comprehension, or is it more efficient for an attorney to be assigned to do that before appearing?
You sound like the trial judge at Hopi. I'm going to have to do what? For how long? Monday morning it's going to turn into Tuesday afternoon. Yes, it seems like it's more efficient, but you're going to see under the model code they expect you to do both. They expect both the attorney and the judge to do the same thing, to very clearly explain the whole list of things to their client if they're the lawyer or to the youth if they're the judge. And it's a double, it's a redundant system on purpose, I guess. It is less efficient, but it is more rights protective. The other thing that happens at the initial hearing is the probable cause determination, and that is like a little baby hearing. So that does require lawyers to go over things. But I hear you. It's a lot of work to sort of go over and over this with a young person. And, of course, those who study adolescent brain development are arguing that they will never really understand, especially as we get younger in the age brackets. So, yeah, I hear what you're saying. And the model code would say, tough, you got to have this redundant system in there just to, to be sure to protect the rights of young people. Did you have thoughts on this, Anna?
I guess not thoughts, but concurring opinions. It seems like it's a lot to take on if you were to adopt this in whole and decide that this is the way you were going to conduct your processes. And so I can see that, administratively, do you have the capacity to handle that? And so another part of that is, ensuring fairness. And so we really do want to have due process and fairness in our proceedings. And so looking at the commitment your staff has to make to ensuring that you're following whatever code you adopt. And adequate training, I think that's important.
Yeah. Yes, you definitely have to have the training. one thing that pops into my head is checklists. I mean, I know what tribes will do. If they adopt this code, they'll make a checklist of all of these things that a judge has to say to a young person. And maybe they'll even give them a little handout before they come into court. And maybe they'll have the probation officer make them check all the boxes and sign at the bottom that they understand. And then the judge will say in the initial hearing, did you read it? Did you sign it? And they'll say yes. And then the Hopi Appellate Court will get an appeal about how that did not comply with Section 2.08.130 initial hearing conduct, because the judge did not advise the child in language the child will easily understand of all the following. So this will cause appeals. I can see it already. And indeed, I've heard an appeal like this already in my own system. Okay, I'm going to the next one because we could nitpick that one to death. Okay. So remember also that initial hearing does have like a little baby hearing process on it that's legal. And this is the probable cause determination. So the judge has to, the judge actually has to find that there's probable cause for this case to even be in the juvenile court. If they can't find it, they have to dismiss the delinquency petition. So I'll read you the wording here. So at the initial hearing, the juvenile court shall enter a written order dismissing the delinquency petition unless the juvenile court finds that the delinquency petition establishes probable cause to believe that the child has committed a delinquent act. And then I went and pulled the definition of probable cause for you because you should always do that, pull the next definition to see if it makes sense. So probable cause is, and remember, this is what the judge is trying to think, or this is in the judge's thinking. Is there a reasonable amount of suspicion here that is supported by the circumstances sufficiently strong to justify a prudent and cautious person's belief that certain facts are probably true? So is it probably true that he stole a car? Well, how would I know that if I'm the judge? Well, the juvenile presenting officer filed a delinquency petition, and he says in the petition, you know, this youth is alleged to have stolen a car under this section of the Tribal Law and Order Code for theft. And if that's all the petition says, well, how do I know that these facts are probably true? Have they given me any facts? Well, if I look back in that petition as a judge and they lay out, well, you know, this is how I know that they stole the car. You know, so-and-so witness says they saw him steal the car, and here's an affidavit from that witness attached to the petition. Well, now I have some facts to work with. I start to get more information out of that petition, and this looks like it might be true. So if it's true, then I as a judge can find that there is probable cause to believe that this youth stole a car. And so at the initial hearing, I'm going to make that finding, and then I'm going to restate the facts that were put in the petition by the juvenile presenting officer. And I'll put that into my court order for my finding of probable cause. Now remember, if a judge cannot do that, and if a judge cannot do that, then they have to dismiss the delinquency petition, and the whole thing leaves tribal court, and it's out. It's completely out. It's not even in the diversion process. So I guess one of the, there's sort of two big things here. You don't want to push a case through the tribal court process if it can't clear this probable cause determination. So if you don't have enough evidence to clear this hearing, then there's really no point in having this hearing on that evidence. And then there's a second aspect to this. If the juvenile presenting officer doesn't know how to write up that delinquency petition, if they just use check boxes and cite to the criminal code, but they don't give any facts they don't have, no one's investigated what happened and actually found witnesses and statements and other information and put that in the petition, then it's not going to clear this probable cause hearing, and the whole case is going to get dismissed. So a lot can go awry here and knock the case out of the tribal juvenile court. And Anna, I know you are a prosecutor. Do you have any thoughts about this?
I know that we had probable cause affidavits that were filed when we would go in, and so I know that that's something, like we were talking about earlier, just what you said, that there's adequate training on what would be filed, and then, you know, clearly indicating, and if you have a bench book or if you were to adopt this, you know, addressing what must be found in each hearing, and the burden of proof for all of that.
Thank you. Sorry about that little noise in the background here. Okay. All right. So, so the initial hearing is actually more than an informative session, right? It does have all that advisement to children and parents, but then there's also this probable cause determination that a judge has to make that is either going to knock the case out of the system or keep the case going to trial. All right, so let's move from the initial hearing to the actual trial, to the adjudication. And this is all assuming that the case is not diverted out one of those 4 doors that we were talking about. Okay, so in my many years of working with tribal courts, I often heard this quote. In most cases, the matter never goes to trial in juvenile court because the youth admits to committing the delinquent act. So what happens in many tribal courts is that at that initial hearing, the judge asks them to plead, they plead guilty, and then the judge asks them to admit, tell me the specifics of what you did. And then the judge accepts that as an admission. Therefore, there's no need to try about whether they try them for guilt in a sense. Instead, you can go straight to the sentencing or the disposition hearing. So that's the way many, many tribal juvenile cases have gone. So if we take away or make it really hard for a tribal judge to accept a guilty plea or to take an admission or accept an admission, then suddenly we're going to have to be holding a lot more trials than we are right now. The other possibility is that a young person might admit to something as part of a diversion agreement, and in those cases, that would be okay, and the code allows this, the model code allows this. It make it possible for the judge to take an admission as long as it's part of a diversion agreement, and then the case gets getting diverted back out anyway. But in all other cases, the model code makes it really hard for the judge to take an admission, and it bumps you to the trial. And so you start to see like all the full-blown Western adversarial process here, almost full-blown. All right, so let me tell you the purpose of this adjudication hearing. And I ended up coming up with, oh my gosh, I have like 6 things here from the code. So the first fundamental purpose of the adjudication is for the judge to determine whether the child has committed a delinquent act. Can the presenting officer prove it? A caveat here is that in juvenile cases under the model code, in juvenile delinquency cases, only the judge is the trier of fact. Only the judge gets to decide what is proven to be true. There's no jury. So you won't find any juries under the model code. A second purpose of the adjudication hearing or trial is to advise them of their rights again. Every time you got to advise them of their rights at every hearing almost. And then the third purpose is to ask the child or the youth whether he or she admits or denies the allegations. So they're being asked to plea in a sense here. and this happens at the front end of the adjudication. If the child admits and proffers an admission, in other words, they offer to spill the details, the juvenile court judge is to conduct an inquiry and may accept or deny the admission. So it is possible for the judge, after following all this process that we're going to look at, to accept an admission, but the code makes it pretty, you have to jump through a lot of hoops as a judge to get it. If they don't accept the admission, then the juvenile court judge will proceed to hear evidence, did he or she really steal the car, and has the presenting officer proven it. So if the juvenile court judge finds that the allegations of the delinquency petition have been proven beyond a reasonable doubt, it will enter this finding in writing in a court order, and it will schedule a disposition hearing. And also it might specify, the judge might specify the placement of the youth between hearings. Where should they reside in this time period? Okay, so I'm just giving you like the highlights of what might happen in an adjudication. So now let's go and look at a fact scenario. All right, so I tried to think of a typical kind of thing that might happen with youth on a reservation, and then I finally just relented and remembered a story from my own childhood and put it into the hypothetical because it's real. So I'm giving you this sample allegation so that we can work with it as we work through the provisions in the code. So first of all, at the top of the slide here, the model code, remember, defines a delinquent act to be an act committed by a child that would be a criminal violation of the tribal code if committed by an adult. So basically, you're going to go look up your tribal law and order code, and here I chose assault, simple assault. I went to my own tribe's law and order code, which is the Hopi code, and I looked up the definition of assault. So assault is defined as a person, it's where a person commits assault by. So the very first thing here is you have to have a person doing it. It can't be a dog or a cat. It has to be a person. A person commits assault by attempting to cause or recklessly causing physical injury to another person. And then I put the definition of reckless down here just in case we end up there. So under Black's Law Dictionary, reckless is defined as conduct such as to evince disregard of or indifference to consequences under circumstances involving danger to life or safety of others, although no harm was intended. So it's possible that you didn't mean to hurt somebody under this definition of assault, but you still were indifferent to the consequences, and they involve danger to life or safety. Okay, so we have a crime that's defined under the Hopi Law and Order Code. Let's look at some potential evidence or sources of evidence in a fact scenario. Okay, so my little brother is probably going to be very upset with me, but I used a story from his life. We all went to the Hopi Mission School when we were kids, and I changed it just slightly. So some of the kinds of evidence in this fact scenario include things like an invoice and a work order. And so by this invoice and work order, we know that the Hopi Mission School purchased and installed a new super high slide for the playground, a very exciting addition to an otherwise boring playground. Another source of evidence is that 3 boys, Adam, Barney, and Charlie, tell classmate X that it would be funny to lure the boy they do not like, Harold, to the top of the slide and push him off. Classmate Y sees 2 boys push Harold off the top of the slide. And we also know that at recess on Monday, September 15th, the Emergency Medical Services is called to respond to a boy named Harold who is found to have a broken arm and other bruises. And then I would add one more classmate in here, classmate Z. Classmate Z hears a rumor that Adam and Barney pushed Harold off the slide because Harold's dad was chairman and fired Barney's dad. Okay, so now we have a story to work with, and we can sort of assess here whether or not we have assault. Let's assume that a delinquency petition is filed against Adam, Barney, and Charlie. So we have 3 boys who have delinquency petitions filed against them in the juvenile court, and the presenting officer is going to have to prove that they committed assault against Harold. All right, so sort of keep that story at the back of your mind, and we'll start moving through some of the provisions in the model code. But let me just take a breath there. Anyone have any comments or questions so far?
You all can put your comments in the chat box, and you can use the Q&A box. And I believe if you do type a question, it doesn't broadcast your name or anything. It comes to us as the presenters. So feel free to enter any questions, and we'll be happy to answer those. I did see a comment from earlier about the importance of diversion, and it needs to be of great quality.
Oh, I see it now. Oh, I very much agree with that. If the diversion is not good diversion, then, you know, what are we doing? Okay. Okay, so in the next 5 slides, we're just looking at some of the preliminary issues in the code that are important to adjudication or trials under the code. And I just gave you that little story so that we could play with some of these ideas. So the very first set of provisions here deals with a standard of proof. So it's very common in tribal codes, and actually in all court systems, for judges to have to meet a standard of proof when they're weighing evidence in a case. And the model code has 2 different standards of proof, and I wished I'd put them both up. Well, I did. One's coming in a later slide. But I wanted to show you 1.07.150. So basically, the juvenile court under the model code requires a standard of proof that's called preponderance of the evidence. So the judge has to find that there is a preponderance of the evidence in most questions that are brought before him or her, except for a finding that the allegations of a delinquency provision have been proven beyond a reasonable doubt. So there's 2 different standards of proof that are operating in the juvenile code, and I just want you to see that. So one of them is preponderance of the evidence, and one of them is beyond a reasonable doubt. But for this slide, I just want you to see the definition of preponderance of the evidence. So the judge is going to look at the evidence put forth by the juvenile presenting officer on whether or not the boys committed assault against Harold, for example. And the judge is going to look at the greater weight of the evidence. And wherever the greater weight of the evidence is, he's going to find in favor of that person. So if the juvenile presenting officer has presented the greater weight of the evidence, some people like to think of this as 51%, then the judge is going to find in favor of that person. And then there's just a note in the definition here that preponderance is based on the more convincing evidence and its probable truth, not the amount of evidence. But you know what, we're in the weeds here. I just want you to see that there's different standards of proof. So I'm going to move forward. Okay, so another issue it would be nice if judges could just use their own discretion and common sense and decide whether something was true or not. But over many decades of evolution of our legal systems in the United States, we've come to develop a big, fat, thick book of rules of evidence and make judges follow these rules and tell them when they can or cannot consider certain bits of evidence or testimony or documents that are put before them to decide whether someone is guilty or not. And if judges don't follow these rules, then their court orders get appealed to the appellate court and they get overturned. So, and I'm simplifying this greatly, but I just want you to understand that that judges have a lot of, their hands are tied in many ways. Okay, so the model code actually under its 1.07110 states that proceedings before a juvenile court shall be governed by the rules of evidence and procedure which govern proceedings before the tribal court. And I just need to take a moment and break that down for you. So it used to be that most tribes did not use any formal rules of evidence at all, even in their adult criminal court. And now more and more are incorporating in formal rules of evidence into their laws, which tie the hands of their judges in terms of what evidence they can take to figure out whether somebody committed a crime, for example. Now, most state governments and many tribal governments have copied their rules from the federal rules of evidence, and that's a book it's a thick book. Now, when tribes have copied in some of the federal rules of evidence, and some have taken the whole book, they will modify it or simplify it down. And a tribe may have copied the rules of evidence from the state court system as well. So it's unclear. You're going to really have to go back and look at your tribe's laws to see, and I would look at your criminal law to see if there is an incorporation of the rules of evidence. And if so, that is going to apply to your juvenile court process. Now, that said, the model code of 2016 does hardwire in some rules of evidence anyway. And whatever exists in your tribal system before you adopt the model code will be overridden in juvenile court by the model code provisions. So this is a very confusing conversation I'm having with you right now. But I want you, if there's only one thing you take away from this slide, is to go find out whether or not your tribal court uses rules of evidence, and if so, where does it come from? Is it the federal rules of evidence? Was it copied from the state rules of evidence? Do you have your own tribal code of evidence? Go and figure that out, because that's going to matter to your juvenile court process. Okay, any questions or comments on evidence, rules of evidence?
I was just going to comment that even if you're not a judge or a prosecutor or a defense attorney, if you are going to be ancillary to providing services for youth in the justice system, just having a baseline understanding of, what we're discussing today is important, so that if you are an advocate and you're sitting with your youth, that you understand, what's happening in the proceedings. So I think that's really important, cross-training, and that's the same for if you're a legal services provider, having baseline understanding of, behavioral health, and when someone is making an offering about treatment or options to serve the youth, that you understand the language that they're utilizing.
Yeah, and I did put in a little bit of a graphic here. I wanted to demonstrate how complicated the rules of evidence are. So one of the more well-known evidence rules is about hearsay. And think of hearsay as, so you're in the context of a trial and you have a judge and he or she is taking evidence. Hearsay would be things like information received from other people that one cannot adequately substantiate, or rumor, or gossip. And in my example, for example, classmate Z, here's a rumor that Adam and Barney pushed Harold off the slide because Harold's dad was chairman and fired Barney's dad. So classmate Z, their statement is hearsay. And on the left-hand side here, there's a whole diagram about how you figure out whether something is hearsay. So you might work yourself through that diagram and go, oh, that's hearsay. But under the federal rules of evidence, there's a whole bunch of exceptions to hearsay. Look at the diagram on the right-hand side. Then you go, oh, good Lord, that is a lot of dissecting to do to figure out whether you can introduce this classmate statement to the judge as evidence. So lawyers go to law school to learn that stuff. Is it hearsay, and what are the exceptions to hearsay? So that's an example of how complicated it can get. We certainly don't expect you all to know all of that, but you should at least, get your hands on your rules of evidence if you have them, and pop it open and just look at the table of contents so that you can see some of what is involved here.
Right. I was going to admit I started sweating a little bit because I thought you were going to give me a hearsay quiz.
I could, but that would be cruel and unusual punishment.
Yes.
I find it's easier just for us in Indian country to think about it as gossip, because honestly, a story can start in one village, and by the time it reaches the other end of the reservation, the story has gotten so wildly dramatic. It's like a game of telephone. And you can't use that information in court because it's not reliable.
Exactly.
All right. So I can see that I have probably less than 20 minutes left here. I was going to stop at 11:50 to see if we have questions, or what do you think, Anna? Should I keep going?
Yeah, let's keep going, and then we'll pause closer to the end for any wrap-up questions or comments.
All right. I will keep chugging along here, and we'll see how far we can get. I just want to give you, let you dip your toe in the water with this model code so you can sort of see where it's going. And I think we have a pretty good idea of what's happening at this point. So some of these rules of evidence have been hardwired into the model code for juveniles. Because the drafters of the model code were defense attorneys, they picked out certain rules that they thought were extra important to protect youth. And they locked down some of these in 2.01.190. So they're basically tying the hands of the judges here, and they're saying, hey, judge, anytime you get a delinquency petition under this law, no out-of-court statement which would be inadmissible in a criminal proceeding before the tribal court shall be admissible to establish the allegations of the delinquency petition. So they're basically saying, and when you see those words, no out-of-court statement, think hearsay, think gossip, think rumor. Those kinds of unreliable statements, it cannot be used to prove that the boys pushed Harold off the slide or that the youth stole a car. They're not reliable information. And they say which would be inadmissible in criminal proceedings, and I assume they're dancing very carefully around the fact that they don't know whether or not the tribe has adopted the federal or any other rules of evidence here, and they're trying to capture the essence of some of those rules, certain rules they found especially important here. Okay, another one here is that no evidence which would be inadmissible in criminal proceedings before the tribal court because such evidence was illegally seized or obtained shall be admissible. So you can't have illegal search and seizure. Let me give you an example. When I was a kid on the Hopi Reservation, 1 year the BIA police, in conjunction with the schools, decided they were going to do a strip search of all the kids going to school on the bus. So they pulled over a bus on the side of the road. I don't know how they actually did it. I heard about it. I didn't see it with my own eyes. But they strip searched the kids that were on that bus. There's a pretty strong case for illegal search and seizure there if they found any paraphernalia or drugs or alcohol on those kids. So that's an example of the kind of evidence that would be inadmissible. You couldn't use anything you found in that search against that kid to show that they were illegally possessing drugs, for example. Also under C, you can't use statements made by the youth to the juvenile case coordinator as evidence that they committed the delinquent act. And D is really important here. So an out-of-court statement made by the child shall be insufficient to support a finding that the child committed the acts alleged in the delinquency petition unless the statement is corroborated by other evidence. So here they're making it really hard for you to use anything said by that youth out of court to find them guilty of whatever they're being alleged to have committed here. You have to have other evidence separate from what they said. You know, somebody saw something. There's other kinds of evidence. You have to have other evidence here to find that they committed the delinquent act. Okay, so that's as far as I'm going to go on this one. But you can just see they've taken and locked down some of the rules of evidence here in the model code. And they're requiring a lot more evidence collection here so that it's admissible in the trial. Okay, let's go on to a slightly different topic, which is the privilege against self-incrimination, or otherwise known as the privilege of silence. So every time a young person comes before a judge, that judge is going to advise them of their right to remain silent, and that the fact that they remain silent can't be used against them in proving anything against them. Also, there's B here, which says that no statement, admission, or confession made by, nor incriminating information obtained from a child in the course of screening, assessment, evaluation, or treatment shall be admitted to evidence. So if they go to see their doctor or their therapist or even their case manager probably, anything they say as part of those exchanges that are therapeutic, that information can't be used as evidence against them either. All right, let's do an easy one. Advisement of rights. Again, we have the advisement of rights. So all hearings, every time, Daniel, the judge, every time they have a hearing, they're going to have to go back and re-advise the rights. So the juvenile court shall advise the child about the nature and purpose of the proceeding, about their right to counsel, their right to remain silent, how the evidence could be used against them, their right to an appeal. This is a shorter list, but it's still the mandatory list here. All right, so let's come back now and look specifically at the adjudication. So I've already told you the purpose statement. I'll just remind you here. So the adjudication is the trial. It's where the juvenile court is conducting a trial to determine whether the child has committed the delinquent act. So did those boys push Harold off the slide and break his arm? Did they commit assault? Well, the presenting officer is going to have the burden of proving that the boys committed assault. And they're going to have to prove it beyond a reasonable doubt. So we need to know what beyond a reasonable doubt means. And it's a standard of proof, and it's the highest standard of proof. You'll notice in the diagram, I just pulled this from the web. Notice all the categories of blue here where someone is not guilty. You know, they could be proven to be not guilty at the bottom, or somewhere in the middle they could be perhaps guilty, or way at the top, the very top blue one, their guilt is highly likely, but they're still not guilty because you have not proven beyond a reasonable doubt that they're guilty. So guilt beyond a reasonable doubt is a very high standard of proof. And I'll just read you the definition. So in criminal cases, the standard of proof is significantly higher than in civil cases. Instead of having to prove a case by a preponderance of the evidence, that 51% I showed you earlier, instead of just having to be more convincing than the other side, the side making the claim, here the juvenile presenting officer, has to eliminate any reasonable possibility that they are incorrect. If they leave the slightest doubt in existence after the case is over, then the side making the claim will lose. So the presenting officer can't leave the slightest doubt that the youth, in our case, I have to remember their names again here, Adam, Barney, and Charlie committed assault against Harold. If there's the slightest amount of doubt, they're going to lose. So if they put a witness on the stand, classmate Z, who heard a rumor that Adam and Barney pushed Harold off the slide, the juvenile presenting officer is going to lose because, first of all, that won't clear the out-of-court statement bar, the hearsay bar. It won't get admitted into evidence. But if they put classmate Y on the stand who saw, let's say, Adam and Barney push Harold off the top of the slide, they've got a lot more, and that gets admitted. They've got some evidence to go with. Now, if somebody else testified, well, I'm not sure if it was Adam and Barney. It might have been Barney and Charlie. It was one. It was two of three. Well, now we have some doubt, right? We have a slight bit of doubt. So, you know, that may cause the juvenile presenting officer to not be able to meet his burden of proof. Okay, I'm going to just pause there for a second. This is a lot of process. I mean, we're pretty much into an episode of Law and Order on TV here. We're in the trial, and we can see that this code is really moving us away from wrapping everything up in a preliminary hearing, and it's forcing a lot of cases to actually go to trial. The other alternative is that young people go in before the juvenile case coordinator, and they do those conferences, and they do an agreement, and as part of that, they do an admission. So that could be a way of using this code to really avoid trials. If you can get children and parents or youth and parents to agree to those diversion agreements. Okay, any questions or comments so far?
I don't see any questions right now.
So right about now, your eyeballs should be rolling into the back of your head. Because when we get into all of this legal process, it gets very dry. Although if you're the youth or a criminal defendant, it gets very scary and harrowing because people can affect whether you go to secure detention or not for long periods of time. Okay, so let's move ahead and just see how far we can get here. So there is another provision that talks about, oh yes, okay, I remember this. So on top of all that other advisement of rights that we were looking at, There's even more inquiry. They call this now inquiry, not advisement, required by the model code. So under this section 2.10.170, the judge has to conduct an adjudication, and at the beginning of that hearing, they do the advisement of rights, but then they do an inquiry as to whether the child admits or denies the allegations. Okay, that's the pleading. And then let's look at the next one. Let's assume that the child says, I did it. I plead guilty, in a sense. And let me tell you the details. So under this 210.190 section, the judge, before accepting that admission from the child, has to do this inquiry. So first they have to ask the child in language the child will easily understand about the number and duration of meetings that they've had with their lawyer. He's going to ask whether the child is satisfied that their lawyer conducted a thorough and factual investigation. The judge is going to ask the child whether he or she is satisfied that the lawyer answered the child's questions and clearly explained the nature of the proceedings, the purpose of the hearing, the process, what happens if the child denies the allegations, if they say they didn't do it, or if they say they did it but the judge won't accept the admission. Also, whether the child is satisfied that their lawyer has clearly explained their rights, the alternatives to doing an admission, and what are the likely consequences of an admission. So in a way, this inquiry by the judge of the child is about the lawyer. The judge is checking in with the youth to see if their lawyer has been doing his job, his or her job, and whether the youth is satisfied that it's taken place. And then let me show you one more side of this. There might be three more. No, one more. Proper of admission. So after that happens, the juvenile court judge then does another inquiry, and this time of the lawyer, asking the same thing. You know, how many meetings have you had? How long were they with the young person? Did you do a thorough factual investigation? Did you research, investigate, and address any legal issues presented? Are you satisfied that the child understands and that there are no competing factual or legal defenses or arguments which the court should hear or consider before accepting an admission? So there's an inquiry of the youth, and then there's an inquiry of the lawyer, and then there's an inquiry of the juvenile presenting officer, whether the officer is satisfied that there is independent evidence admissible to corroborate an admission by the child. So the judge is actually asking the prosecutor, you know, assuming this child doesn't admit or we don't take the admission, do you have some other evidence that they actually did it? So these inquiries at the front of the adjudication are like a whole extra layer of protection of the rights of the young person, making sure that their defense counsel did their job, making sure the child understands the consequences of admitting and the choice of making an admission, and whether there's other evidence that the prosecutor is relying on in this case to go forward. And there's even another section here, and I'm going to skip it, on slide 37, where there's an inquiry of the juvenile case coordinator. So you might be now thinking, good grief, that is a lot of inquiry on the front of this hearing process. I guess if I sort of step back from it, I would say that there must be a lot going awry in the state juvenile court process that these kind of elaborate procedures are put in the model code. There must be a feeling by the defense counsel for Native youth that find themselves in state juvenile court that Native youth are really just getting run over. And so all these protections are getting put into the tribal court process. And I'm not saying it's bad to put it in. I actually would love to have the resources to do this well for young people. But at some point, you're going to have to make a decision in your systems about where you put your money. Are you going to put it into programming and services? Are you going to put it into lawyers and, you know, all of the rights process? Can you do some of both? Those are hard allocation decisions, and it might affect what provisions you scoop up from the model code. All right. So I'm just going to skim through here and see if there's anything here that I really want you to see. Or maybe I can do them all more quickly. Let's go to the next one. So the next provision in the model code is looking at whether the juvenile court can accept an admission by the child. And they have to make, the judge has to make findings in the adjudication that the child understands, their rights, and then also that they voluntarily, intelligently, and knowingly admit the facts that support a finding that they committed the delinquent act. So the words voluntarily, intelligently, and knowingly are kind of magic words or terms of art in the law. It's a way you waive your rights. And a judge has to find that they waived their rights in a sense here, and they did it voluntarily, intelligently, and knowingly. Also, that there aren't any facts that would be a defense to the crime here. So the judge has to check to make sure there aren't other defenses that the child could invoke. Okay, that's good. We'll go to the next one. So what if the child pleads not guilty? They deny the allegations. What happens then? Well, according to the code, then you actually start to hear evidence in the adjudication. And the code requires that if the child refuses to speak or answers evasively, that the judge is going to have to count that as a denial of the allegations and proceed on to trial to hear evidence. All right, so what are the findings on adjudication? So let's assume that the judge accepted an admission, or let's say it didn't and it heard evidence, and that the juvenile court judge finds that the allegations of the delinquency petition have been proven beyond a reasonable doubt. What happens at that point under the code? Under the model code, then, the judge has to enter this finding in writing in a court order. It has to set the matter for disposition. That means it needs to schedule another hearing for sentencing or disposition. And it needs to specify whether the child is to be continued in any out-of-home placement. That's kind of always something that has to be done at the end of a court order. You have to come back to where is the child now? Can they stay there? Do they need to go to another place? If the juvenile court finds that the allegations of a delinquency petition have not been proven beyond a reasonable doubt, it shall enter a written order dismissing the petition and releasing the child. So if the presenting officer doesn't make their case, then the whole thing gets dismissed out of the system and it leaves the juvenile court system. Okay, I managed to get all the slides in there. So I'm going to stop there. I would just say before handing this back to Anna that there are a lot more provisions in the model code that we didn't cover. There's a whole bunch of provisions on custodial, taking kids into custody, temporary custody and placement. There are a whole bunch of provisions on secure detention, what that can look like and how you can get it and how you, but more likely how your case gets dismissed if you don't follow the rules. So when you have time or if it's important to you, you should take a look at the entire 2016 model code, which is I can see in your download box here, the second box on the bottom. 2016 model code, you should actually print that out and take a look at the table of contents. All righty. Anna, I'm going to hand it back to you.
Thank you, Pat, and thank you so much for everything that you shared today. We do have a comment in the chat box, and it was about, I've worked in tribal youth court for over 20 years, and I still am challenged explaining to youth, or even the parents for that matter, what stipulating to probable cause means. At our preliminary inquiry hearings, there's a point where the judge asks the youth, do you stipulate to probable cause, or do you want to hear testimony?
That sounds to me like another way of saying, do you admit that you did it? And are you going to tell me the specifics of that? And if you don't admit, we're going to have a trial. You know, I think it really intimidates kids and their parents if they think they're going to actually be in a trial. And that might cause them to admit. Yeah, a stipulation is a kind of admission in my book.
Right, and I was thinking the same thing earlier. I know there's like a number of law review articles that you could go deep into preliminary hearings and probable cause. But I think, you know, an assessment of what we've done a walkthrough of is that if you're working with your team to develop your tribal code, you all can start by looking at the Model Indian Juvenile Code and assess whether, you know, are there portions of it that would be an improvement to your current code, and then are there portions of it that, you know, at this time you wouldn't be able to adopt for whatever reason. And so I'm really thankful that Pat has offered both sides of that, and we just wanted to provide this as a resource to you, supportive to enhancing and developing your tribal code. And so if you are able, Session 5 is going to be on Thursday, August 16th, and you can register for that. Our guest presenters will be Pat again, and then Lauren Van Schilfgaard of the Tribal Law and Policy Institute. And so that session will be specific to supporting Healing to Wellness Court juvenile referral and diversion provisions. And so we really look forward to that session and hope that all of you that are working on juvenile healing to wellness will join, and definitely those that are interested. And so please register for that. It's on the initial invitation that we sent out, but I'm going to put that in the chat box if you want to register for Session 5. And if there's any questions, feel free to put those in the question and answer. We do have a couple of minutes if you have any questions to close out. I know we still have that lingering question of, you know, if any of our participants have had a chance to review the code in its entirety, any concerns, or if your teams are going to be taking a look at it to see if there's provisions that you're going to adopt as you look at enhancing your tribal code. Oh, also on the bottom left is our webinar survey link. Please take our survey. We always take that feedback into account when we look at our next session development, and it really contributes to helping us put on good webinars that are helpful to you, and so we appreciate the feedback that we get. We have a comment. Do you have comments on trying to get delinquency cases transferred from state court to tribal court? And Pat, do you have thoughts on that, on transfer from state court to tribal court?
Yeah, so the thing that jumps out at me is you should take a look at the joint jurisdiction tribal healing to wellness courts and how they are entering into memorandums of agreement with their state counterparts to move cases from their state dockets to their tribal dockets. That is being done. It's definitely being done in Alaska. It's also being done in the lower 48, and Anna may know better. And if Anna doesn't know, Lauren, who comes on next week, will know, and you should ask her that question again. Yes,
we have several courts that we work with that have memorandum of understanding in place, and they're able to set up. That's a really vital aspect of the referral process. If you have a local county or state partner that's willing to develop an agreement with you, those are really important to having effective referral processes. And so we can have some examples on session 5, but you can reach out to us individually. Our email addresses are on the bottom there. Feel free to email me and I can connect you with some resources related to that.
Yeah, I'm not sure how one would do it case by case, but you can definitely do it system-wide if you can get an agreement in place. Well, actually, I have to say, if you did it case by case, you could write a letter to both judges or make a motion before both judges and ask them to do it, and they might just do it if they are not statutorily prohibited from it.
Right, I was going to say, unless there's something that bars them from doing that, there's the option of even if it wasn't a healing to wellness, but just a regular juvenile diversion transfer, maybe just filing a motion in the state court case and making your case to the judge and seeing if they'd be willing to agree to a transfer.
Okay, I don't see any more questions unless you do, Anna.
I don't either. I was just checking the Q&A box. So with that, thank you all for joining. Please take our survey. Please join us for session 5. I know Lauren was saying she's already been working with Pat to prepare, so we know it's going to be a great session. We look forward to seeing you all then. So thank you so much. Have a good rest of your week, and we look forward to seeing you on session 5.
Thank you, everybody.
Thank you.